Members, it's the appointed time and we have formed our quorum. Please invite the administration to join us. And before the officials have arrived, may I remind members that before you speak, you will have a direct or direct pecuniary interest in any of the subjects, so please make a declaration. I am occupied paid position in travel agency, and I am also honorary advisors of an advisor of certain industry-related organizations. For details, please refer to paper CB3 849/1617(01). The administration has prepared a response to questions raised at the last meeting. I'll give the floor to the administration. Thank you, Chairman. Involving matters raised at the last meeting, as you said, Chairman, we have prepared a paper to respond to them. The first is in relation to Clause 80 of the bill, change to prohibition order by Travel Industry Authority. Members asked the basis on which the TIA exercises the power under Clause 18 should be specified. Under Clause 81 of the TIB, for good reason, whether on its own initiative or on application by person against which a prohibition order is made, authorize the person to leave Hong Kong on one or more occasions as specified in the authorization. This clause makes reference to Section 29(7) of the Travel Agents Ordinance. As cases involving prohibition orders differ, TIA needs to be provided with the necessary power to address unforeseeable circumstances in reality, and therefore we are of the view that the formulation of Clause 81 is appropriate. And the second issue is functions of disciplinary committee and relationship between the committee and TIA. In particular, about Clause 91, written directions from the TIA to the disciplinary committee, whether the committee is required to take the directions as reference only, but is not mandated to act in accordance with the directions. The purpose of establishing the disciplinary committee is such that the committee is under the TIA and its function is to assist the TIA to regulate travel agents, etc. So the committee, of course, must be consistent with the TIA on regulatory matters about travel licensed travel agents, tourist guides, etc. And therefore, the TIA must have full control over matters, including appointments and practices, etc., in relation to the disciplinary committee. And therefore, we believe that to echo the legislative intent, because the committee is part of TIA, and therefore its work must be consistent with TIA in order to have an effective regulatory or disciplinary mechanism. Members asked whether Clause 90 can be better written to reflect the policy intent, and that is the in relation to the functions and the chairperson, vice chairperson, etc. The written directions will just be on the practices of the committee and not on specific cases. We agree to this and we will make the necessary amendments. And members asked about resignation and removal of members of the committee. And when a case is going to be conducted or in progress, the resignation or removal of members of the committee breach the requirements under the bill, in particular about the quorum required for a meeting of the DC, we have consulted the DOJ. And under Cap 1, Interpretation and General Clauses Ordinance, Section 51, where any committee established by or under any ordinance, the powers of such committee shall not be affected by any vacancy in the membership thereof. So under normal circumstances, in the case of a vacancy, the subsequent meetings conducted by the DC and the subsequent inquiries conducted by any inquiry committees already established will remain valid. That said, if the member who has resigned or has been removed is coincidentally a member of an inquiry committee already established, and the vacancy concerned results in the inquiry committees in compliance with the quorum for meetings under Clause 102, then the vacancy will need to be filled first by a new appointee before the committee can hold any meeting that is in compliance with the requirements under Clause 102 and continue to handle the same case. In any event, as said at the last meeting, we believe that TIA, from the administrative perspective, will appoint a new member to fill the vacancy as soon as possible. A member inquired at the last meeting whether it is necessary to set out the in-principle grounds on which members may be removed under Clause 89(1). Under this clause, TIA may remove a member of the DC from office if it considers that the removal is desirable for the committee to effectively perform its function. And this is already an in-principle ground, and the formulation of this clause makes reference to Section 5(1) in Schedule 3 to the Property Management Services Ordinance. As regards the Securities and Futures Ordinance and the Insurance Ordinance, whether references can be made there. And we understand that the two ordinances do not have any in-principle guideline for the removal of members from any committee established under these ordinances. So, Clause 89(1) has already set out an in-principle scope, and that the formulation of the clause is appropriate. The Assistant Legal Advisor asked at the last meeting whether it is necessary to further inquire TIA to inform the removed members of the reasons for the removal. Under Clause 89(2), if a member of the DC is removed from office, TIA must give the member written notice informing the member of the removal. And this formulation has also made reference to the Property Management Services Ordinance, Cap 626. There is no requirement for the reason of removal to be disclosed to the removed member. Neither does the Insurance Ordinance nor the Securities and Futures Ordinance contain such a requirement. So we believe the drafting of this clause is consistent with similar ordinances. And regarding a TIA to refer facts of case to chairperson of DC, members asked whether there is an alternative to handle decisions made by chairperson of the committee. For instance, if the chairperson is satisfied that the case is trivial, frivolous, etc. And we must holistically consider all provisions in the bill in relation to handling of disciplinary cases. Now, some are of the view that the time taken for handling disciplinary cases is too long and there is a backlog of cases. We want to ensure that the time for handling cases will not be too long, and we have to strike a balance in order to be fair to the parties concerned. So the TIA will appoint a chairperson, and under Clause 98 of the bill, if the chairperson decides not to proceed with a certain case, then a written notice has to be given to the complainant concerned, containing the reasons for that decision. So the whole mechanism is very transparent, and if the complainant is of the view that the decision merits reconsideration, he can approach the TIA for follow-up, for conducting a further investigation, and then referring all the facts of the case to the chairperson of the DC for reconsideration. We have to ensure that the DC and the chairperson is given the necessary power to carry out regulatory work effectively and efficiently. So we believe our current approach is desirable. Regarding Clause 105 of the bill, what reference we have made in terms of the proceedings of the inquiry committee. Now, we have made reference to relevant arrangements under the Estate Agents Ordinance, CAP 511, Property Management Services Ordinance, CAP 626, and Travel Agents Ordinance, CAP 218. I pause here, Chairman, and I will be happy to answer questions from members. Thank you, Mr. Liu. Members, do you have questions, please? Yes? Mr. Pin Siu Peng. Thank you. Talk about the disciplinary committee, the DC. All right, it will be formed by by the chairperson, vice chair, and also 50 members, and they are to be appointed by the TIA. I'd like to know whether nominations can be made by members of the TIA. I'd like to know the arrangements for the appointment, and the term is 2 years, and the term may be extended or renewed. Is there any limit to the year of service?
Thank you, Mr. Paul. With regard to the procedures of nomination, we'll leave it to the TIA after it has been established. It will also set out the rules for establishing its committees. And if need be, in respect of the operation of the disciplinary committee, should there be any subsidiary legislation, we will consider that after the principal ordinance is passed. As for the 6-year rule, we believe that members of the disciplinary committee will mainly be coming from the TIA. And the TIA, within the public officer arrangement, the 6-year rule applies. As for non-TIA members who are appointed to the disciplinary committee, then that will be something to be looked into by the TIA, but we will try our best to enable different people to participate and contribute to the work of the TIA. I think the TIA will consider whether the 6-year rule will also apply to non-TIA members who are members of the disciplinary committee. Now you say you believe. So you deal with it flexibly, or will there be a clear-cut rule, say the 6-year rule, will apply? I believe members of the disciplinary committee will follow the operation of similar statutory advisory statutory bodies. and the 6-year rule is more appropriate. All right, let us move on. If there aren't further questions, let us move on. We stopped at clause 98. Ms. Lee, we've completed clause 98. We move on to 99. Chairperson of the disciplinary committee may decide how case to proceed. Now, if a case is decided to be considered, then these are the procedures for dealing with the case. Clause 99 provides for the arrangement to deal with cases that will be investigated. 1 to 4 is set out in 2A. A disciplinary committee is to be set up, and written notice has to be sent to licensee. Under 2B, with regard to minor cases, the chairman may take an expedited way, and it will be set out in subsidiary legislation as to how it can be expedited. In respect of Section 108, 1A, B, C, D, E, such as warning, fine, or imposing certain licensing conditions, included in 2B. As for 2C, the chairperson may recommend that the authority revoke or suspend the licensee's license in a summary way. The summary proceedings will be spelled out under Section 112. As for the decision under 2B, which is the expedited way, subclauses 5, 6, 7, 8 provide some principles. The chairman may take into account the criminal record or the conviction record of the licensee and also previous orders of the TIA and TIC to make sure that there is a smooth interfacing, and also written notice will have to be made to the licensee. That's clause 99. Any queries? If not, then please move on. We now turn to clause 100. 100 to 104 deals with the inquiry committee. This is about the composition and general procedures of the inquiry committee. Composition of inquiry committee is in clause 100. There should be a chairperson and at least 2 ordinary members. That's clause 100. Yes, I have a question. The inquiry committee is made up of 3 members, at least 3 members. Will the meeting be held in parallel or just one committee at a time? Will there be several committees holding meetings in parallel because of the number of cases? Chairman, thank you. The arrangement is to enable the disciplinary committee to set up several inquiry committees, and members or membership of the inquiry committees can be duplicated, and therefore several inquiry committees can be held in parallel so as to deal with the number of cases. Is there a cap? No, there is no such arrangement at present. Who is to decide on the number of members? The disciplinary committee chairperson will decide. That's 100 sub 3. Clause 100 sub clause 3. So he will make a decision, but is it according to the nature or according to the number of members or the circumstances at that time? Is there any guideline? Well, we believe that it should be up to the chairperson of the disciplinary committee, the number of cases, nature of cases, and also the membership of the disciplinary committee. So the law will not spell out the details. Your understanding is correct, Mr. Chairman. All right, if there is no question, please move on. We now move on to 101. That's about the general procedure of the inquiry committee. If need be, subsidiary legislation can be enacted. Other provisions can also be decided by the committee. The chairperson will chair the meeting of the inquiry committee. That's 101. Ms. Chiang, 5 minutes. Chairman, if you don't mind, I will digress a bit. We are now looking into the disciplinary committee and then the inquiry committee and also the appeals board or appeals committee. You may have explained that before. I just want to know the relationship between these from where to where. Say the chairman or chairperson of the inquiry committee will be appointed by the Bureau, or rather by the TIA. Well, I don't know whether I've missed anything. With regard to the future TIA, the panel or board, what exactly is the composition? Can more information be provided? Can you tell me briefly? Yes, please, briefly. Say something on that concerning the committee under the disciplinary committees under the disciplinary committee. Would there be a chart spelling out the different functions? Thank you, Chairman. Thank you, Ms. Chiang, for the question. I think it was quite early that we made an introduction to that. Let me briefly repeat. The TIA has its own members, its own board. And then the disciplinary committee is one of the committees under the TIA, which is specifically tasked to deal with disciplinary matters, and we discussed that before. And the TIA can also have other committees. The disciplinary committee is the disciplinary mechanism, and therefore, to discharge its duties effectively, the disciplinary committee will set out directions and make directions. As for the actual disciplinary hearing, as explained by Ms. Lee, the disciplinary committee will form different inquiry committees. And an inquiry committee is formed upon each case. And the minimum membership is 3 for each inquiry committee, depending on the actual situation, and will be adjusted accordingly. As for the inquiry committee, the majority of the members should be non-tourism-related members to make it fair. Depending on the nature of case, or depending on the situation, there may be several inquiry committees to effectively deal with the large number of cases. So that's briefly from the TIA to the disciplinary committee to the inquiry committee. Ms. Chang has asked about the appeal committee. If an inquiry committee has made a decision and say its decision is that a certain licensee, whether a travel agent or a tour guide, has breached the disciplinary rules, and the person should be disciplined, say a warning should be issued, the licensee may be aggrieved, may feel aggrieved, he or she may appeal to the appeals committee. As for the membership of the appeals committee, to be fair, like similar appeal bodies of supervisory bodies, is something outside the TIA. The appeals committee is appointed by the Secretary for Economic and Trade and Development. And the appeals committee, appeals board, is bigger and is made up of different members. It can also set up different appeal panels to deal with the appeals. And the appeals board will conduct a hearing and listen to both sides and make a decision as to whether the appeal is upheld or whether the appeal is rejected. The appeals appeals board will make a decision according to the facts. Okay, you clear about it? On the whole, are all members of TIA appointed by the CE, the Commissioner? Yes, we discussed that before. You might have mentioned that before. I might have missed that. Thank you. Sorry. Well, afterwards, I will ask you and try to understand more about it. Next, Mr. Look. I have a question concerning the inquiry committee. Whether that will happen. Now you need 3 members at least, 1 chairman and 2 members. And the members will have to be members of the disciplinary committee. But if no one is willing to be a member, is there any fallback plan? Say, all 18 members of the disciplinary committee, for one reason or another, don't want to be a member of the inquiry committee. Is there any fallback plan for the formation of an inquiry committee, or is it mandatory for the disciplinary members to be inquiry committee members? The Assistant Commissioner. Thank you. Thank you, Mr. Luke. Thank you, Chairman. This is a hypothetical question, hypothetical situation at present, including Chairman, Vice Chairman, and 15 members. There will be 18 members altogether. Say because of conflict of interest or because of clashing of time schedule, the situation described, the special situation described by Mr. Luke may occur. In that case, more members will have to be appointed to the disciplinary committee to ensure that there are adequate members to form an inquiry committee. I believe the chance of such a situation is not high. Yet, under the proposed arrangement, according to the bill, more members can be appointed to ensure that there are adequate members in the disciplinary committee. Mr. Luke, with regard to the 18 members of the disciplinary committee, it's not a ceiling, is it? Now, Clause 87(2)(c) says that there should at least be 15 ordinary members. So this is not a cap, and we can add more.
Well, these members have to be from TIA. Can non-authority members be members of the DC? Thank you. 87(4)(b) says that at least 8 of the ordinary members are members of the authority, of whom at least half are non-trade members. As said in the paper, in response to issues raised at the last meeting, the DC is under the TIA. We have to ensure that the DC is consistent with the TIC in regulatory matters. So there will be a lot of authority members in the DC. Any questions? Any further questions? No? Then please go on. Clause 102. Quorum for the meeting. Subclause 1, the quorum is 3 or half of the members of the committee, whichever is the greater. Let's say there are only 3 members, and the quorum has to be 3. And if the number of 4, then again it's 3. And it is when the number of members have reached 7 that the quorum has to be 4. And in subclause 3, you can see that a meeting may be conducted only if a majority of the members present are non-trade members. That's for Clause 102. Any questions? No? Please go on. Clause 103, voting and meeting. This follows usual meeting procedures. Each member present will have one vote, and if there is a tie, then the chairperson has a casting vote. And this is the ordinary arrangement for committees. Please go on. 103, 104, parties to inquiry. We find this necessary in the drafting stage, and the parties to inquiry are the licensee concerned, the authority, and the complainants, if any. That's Clause 104. Yes, please go on. Clause 105 is a bit longer. Proceedings of inquiry committee, together with Clause 106. These two clauses will set out the powers of an inquiry committee in conducting its business, and this is consistent with powers set out in similar legislation, such as the real estate agent ordinance. Clause 1. Subclause 1, the inquiry committee has powers such as power to take evidence on oath, to summon a person to attend the inquiry, and the 105.2, the inquiry may be conducted on the basis of written submissions only, and 3 and 4 allows the inquiry committee to give directions on who may be present. And 5B, 1, 2, 3, a party to the inquiry may participate in person through a legal representative or with the consent of the inquiry committee attend through another person. Well, for a preliminary inquiry, the complainant and complainee, and also the TIA, all three parties may be present. Is it in line with the current legislation? 105 is drafted in a more flexible manner. We have not dictated how such an inquiry should be conducted, but of course the TIC has also got experience, and then TIA may follow practices that are established and proven in the future. So the proceedings used by TIC may be used here. Now, if the complainant wants to be present in person, does he have the power? Or will the decision will be entirely the decision of the chairman? In 105.5b, we said that a party to the inquiry, a party would include what is under Clause 105. The licensee concerned, the authority, and the complainant. And therefore, the complainant may participate in person through a legal representative or with the consent of the inquiry committee through another person. Different ways are allowed. The law hasn't dictated here the way a party may participate in a hearing. Dr. Zhang. That is, the inquiry committee may issue a summons to a licensee. And what if the letter is absent? If, now I will have to refer you to Clause 109, offences relating to inquiries. Now, if the inquiry committee requires someone to be present or to submit documents with a summons, a failure to complying with such is an offense and will be penalized. All right, if there is no follow-up, we can go on. Dr. Junius Ho. Thank you, Chairman. I have questions on clauses 104 and 105. 105F. Evidence, procedure, question of law, another matter in relation to inquiry has the power to appoint a legal advisor to assist and advise the committee on issues I just mentioned. So the legal advisor will just serve the inquiry committee. Now, the parties include the licensee, the TIA, and the complainant. If these parties I'd like to know whether advice given by the legal advisor will be made known to all parties. So I'd like to know whether the legal advisor will only serve the tribunal. Will it have the obligation to be accountable to all three parties? Thank you. Clause 105F is from 2A, the Buildings Ordinance. In Clause 117, we will elaborate on whom the legal advisor can represent. And if I may refer members to Clause 107(1)(a), a legal advice can only be provided when all parties are present. So an advice given by the legal advisor will have to be made known to all parties, and that is under Clause 117(1)(a). If I may, Chairman, ask a follow-up question. So the legal advisor can tender legal advice. And what about legal advice given to the tribunal outside that scope? Will the advice be subject to legal profession privilege? According to Clause 117, when the legal advisor has advised the committee on any question of law as to evidence, procedure, or any other matter in relation to the inquiry, it has to be provided in the presence of all parties. This is to ensure that every party is informed of the advice tendered by the legal advisor. But this is ambiguous. The legal advisor is supposed to serve the inquiry committee, and the committee can seek advice from the legal advisor at any time. The other three parties may have their own legal representatives. According to my understanding, in the court, if the judge would like to meet one of the parties, the other parties will have to be informed. But this legal advisor is supposed to serve the inquiry committee, and if the committee wants to seek his advice on the provisions, so on and so forth, and if all parties have to be informed, then the legal advisor is not really serving the committee. So this is about a legal profession privilege, LPP. I can keep secret or keep confidential legal advice given to me. Now, the inquiry committee is supposed to be neutral. and the onus of proof is on the complainant or the TIA, which will be legally represented. If I have a discussion with my legal advisor, everything should be privileged, and I don't have to be accountable to the other three parties, because this advisor is under my instruction and he should serve me only. I think following the formulation here, I think the inquiry committee is being constrained. Thank you. 117, advised by legal advisor. And which party should be informed of the legal advice given. We have consulted the DOJ and also checked with other pieces of ordinance, other ordinances. There are at least 3 with some arrangements, such as the medical registration ordinance, dentist registration ordinance, and physiotherapist registration ordinance. Legal advice given to an inquiring committee has to be made known to all parties present. And this is for the sake of justice and openness. I don't know whether Dr. Ho is satisfied. Well, I would like to continue to ask for some questions. Yeah, I can give you another 5 minutes. I thank Mr. Lam for his explanation. There was a similar provision in the medical registration bill. I asked which party the legal advisor serves. I raised a question, and then the administration promised to reconsider that arrangement. So is it the government's policy that the role of a legal advisor should be made rather ambiguous? So when after I raised this point at the Bills Committee to study the medical registration bill, the administration promised to review the policy. And just now we're told that 3 other ordinances have a similar arrangement. This is very undesirable. Mr. Liu, I think Dr. Ho has asked an excellent question. For the inquiry committee, because it may result in disciplinary sanctions on to the licensee, and therefore we have made it clear that there will be clause 117. Any legal advice given on any question of law as to evidence, procedure, and any matter, the advice must be made known to the other parties.
It's because of procedural justice. Maybe law drafting experts can supplement. With regard to other legal issues, the TIA or the disciplinary committee can, of course, seek the legal advice for themselves. And such legal advice, as said by Mr. Ho, is not involved in procedural justice, and that, of course, is privileged information as far as the TIA and the disciplinary committee are concerned. Here, it is in respect of handling a complaint case, and in handling such a case, the committee has to be fair and open, and this will not be the ground or one of the grounds for making an appeal or making an application for JR. That's my general understanding. I don't know whether the legal advisor can supplement. The legal advisor. Mr. Lam, according to my understanding, if an inquiry committee has appointed a legal advisor, the legal advisor is to provide his legal advice to the committee. And this is not to be provided in private. It has to be given in the open and in the hearing, so that the parties concerned will know the content. If I were a member of the chairperson of the inquiry committee, and there was a legal dispute or a difference in arguments, I want to get the legal advisor to advise me on that. I want to be direct. Can I ask the legal advisor discuss with the legal advisor in private, and the advice given, some of them is used, some of them is not used, and if somebody, say, if a licensee raised this issue, say, on a certain day, Mr. Chen, the chairperson, what did you say to the legal advisor, and what was discussed? Is it legal privilege? Now he wants to seek legal advice from the legal advisor, then he will have to inform the legal advisor. The legal advisor, in giving advice, will have to give in the presence of other parties concerned. Under 1172, if the committee does not accept the legal advice, the committee will have to inform the parties concerned. Chairman, I find this making the situation more complicated. I don't know whether it's in the other ordinance. Say, I think it is a state agency ordinance. The chairman has to be a lawyer or must have a legal background. And then the chairman, therefore, can make his decision on a legal point, or on a point of law, rather. Now, the chairperson asks for legal advice. What transpires between the legal advisor and the chairperson will be made public, and that is not desirable. That's an overall issue. I think with 117 or similar provisions, that will complicate the case and that will make the work more difficult. Ms. Chang, are you on the same point? No, another question. All right, let us focus on this. It's related to inquiry. Is it related to the inquiry, or is it related to legal advisor, the role of legal advisor? No, not related to legal advisor. Let us finish with this. Okay, let us focus on this. Thank you, Chairman. Mr. Ho is concerned about the role of the legal advisor. The legal advisor represents three parties instead of the inquiry committee. Is it desirable? Now, apart from the medical council arrangement or ordinance, are there other statutory bodies which have legal advisors only providing service to the statutory body per se and nobody else? Chairman, we may need to discuss with the lawyers in detail after the meeting with regard to the case in the inquiry. The legal advice obtained will have to comply with procedural justice, and we have to make known to the parties concerned. I believe that will be acceptable by you all. As for the role of the legal advisor, the legal advisor is, of course, appointed by the inquiry committee, but the inquiry committee has a specific role in dealing with the disciplinary case. And under such circumstances, the legal advice will have to be shared. My question, I heard from Mr. Ho, is that apart from ensuring procedural justice, will there be any room for the inquiry committee to talk to the legal advisor in respect of matters which are not so directly related to the case being handled, and the legal advisor obtained will be some sort of communication between the inquiry committee and the legal advisor, and how should it be made known to the parties concerned? As for this part, we will talk to our legal advisor to see if there is any such room, and how would it impact upon procedural justice of a disciplinary hearing, and whether that will lead to further disputes. All right, let's wait for the document in the next round, or at the next meeting. Thank you, Chairman. Now we have to be forward-looking. This is one of the source of controversies. I know Ms. Chang will ask a question, but I want to make a quick point. Who will write the judgment, whether it's a clerk or legal advisor, who write the judgment in a court of appeal? If it is a tribunal, then the judgment will have to be written by the chairperson. But not everybody is able to do that. And do you have the specification for the duty of the clerk? This has to be discussed at the next time. Ms. Chang, my apologies to you, Ms. Chang, you're wrong. Are there time limits to an inquiry? Say, the inquiry should not last for so many months. I know that in the past, some statutory bodies like the SEC conducted hearings. They formed, say, an investigation committee, and they spent years on a case.
真係筋疲力倦㗎嚇，即係所以我就喺度諗呢
That has caused a very serious problem on the parties concerned. So the inquiry should be dealt with ASAP. Say, the TIA is of the view that this company has a problem. Then the TIA can form a judgment and should not allow that company to continue its operation. And the case should not be dragged on for a long period of time, because it will be a suffering to the complainee as well, the Assistant Commissioner. Thank you, Chairman, and thank you, Ms. Chiang, for the question. The present arrangement is this. As asked by the Chairman, whether there can be more than one inquiry committees held in parallel. Yes, there will be several such committees, and that will help to clear the backlogs or reduce the backlog. The inquiry committee has statutory powers. It can issue summonses and ask the parties concerned to provide information. And if they don't cooperate or comply, then, as we said before, if there is no reasonable excuse, then non-compliance will be an offense. These measures will help to ensure that the work of the inquiry committee will go smoothly and will get the compliance of various parties. We are handling cases in the trade according to experience of the TIC. They are not similar to the cases of the handled by the SEC, which are very complicated. All the work handled by the TIA are related to the operation with travel agents, and they may not require a lot of time to deal with. In our mechanism, there are different ways to ensure that the work of the inquiry committee will go on smoothly. Ms. Chang, do you have a suggestion on the cap? Thank you, Chairman. We don't have a deadline If a certain case, for one reason or another, requires a longer time to be dealt with, then it would not be appropriate to set a deadline. Efficient is important, but the inquiry has to be handled properly and fairly, and that is most important. Thank you. Ms. Chang. Thank you, Chairman. Now, this inquiry committee will at least made up of 3 members: Chairman, Vice Chairman, Chairman, and 2 members. The Chairman is the person who sets up the inquiry committee. Can you clarify this point? I don't want to guess, so I just want to clarify the issue. Thank you. Yes, the Commissioner. Thank you. You may refer to 100, clause 100, on the composition of the inquiry committee, subclause 3. The chairperson of the disciplinary committee sets up the inquiry committee, and the chairperson of the inquiry committee can be the chairperson of the disciplinary committee or a vice chairperson of the disciplinary committee. And in each inquiry committee, or rather in the disciplinary committee, there is 1 chairperson and 2 vice chairpersons. So the chairperson will arrange that he himself or one of the 2 vice chairperson will be the chairperson of the inquiry committee. Please move on to subclause 4. If you don't mind, you can refer to this. You can refer to clause 97.3, which spells out a certain situation. In a certain case, unfortunately, the chairperson of the disciplinary committee has a disclosable interest, and therefore he cannot deal with the case. In setting up an inquiry committee, how should that be done? Under such circumstances, the authority will appoint another member of the committee to deal with, to set up the inquiry committee. And that person will set up an inquiry committee. He can appoint himself to be the chairperson of the inquiry committee, or one of the 2 vice chairpersons of the disciplinary committee to be the chairperson of the inquiry committee. Ms. Chang is concerned about clause 100 subclause 4. That is specifically pertaining to a case of disclosable interest on the part of the chairperson of the disciplinary committee. I don't understand 4A. The person who establishes the inquiry committee, who is to be the chairperson, is the person who establishes the inquiry committee. So who is he? Thank you, Chairman. Thank you, Ms. Chan. That is in respect of clause 97 subclause 3C. The authority may appoint another member of the committee who is a non-trade member, and that person has the power to establish the inquiry committee on behalf of the chairperson of the disciplinary committee.
Why does it look a bit complicated? This is because the chairperson of the disciplinary committee has a disclosable interest, and to avoid any conflict of interest, he will not be the person. But the person who establishes the inquiry committee will be a non-trade member of the TIA. Because the chairperson of the disciplinary committee should be the one to establish the inquiry committee, but because he has a disclosable interest, he cannot do so. And so under 97, when the chairperson has a disclosable interest, then a non-trade member of the TIA will establish the inquiry committee on the chairman's behalf. And he can be the chairman of the inquiry committee. That's the meaning. The chairperson of the disciplinary committee, is he from the trade? No, he has to be a non-trade member. That said, he may has a conflict of interest in a particular case. For instance, he knows the person concerned, it may be his business partner or his family member or relative, then he is not suitable to be the chairman of the inquiry committee to avoid any perceived conflict of interest. And under such a case, a non-trade member of the TIA will have to take his place. I think we are mainly talking about commercial disputes, not really criminal in nature. So there should be a time limit for such hearings. For instance, it should be at most 120 days. If that is exceeded, then it has to be reported to the board for permission to extend. You have to understand that because parties to an inquiry can be legally represented. Of course, the inquiry committee has a legal advisor, but the licensee will have to employ a legal representative because he being a layman in law may not be able to understand everything. Now, this is a very thick bill. I admire you. I think it's not easy to have compiled such a thick bill. The cost, the legal cost can be substantial. Well, the licensee can be a big or small company. Even if it is a big company, the cost is quite substantial. So can we set a time limit for the duration of an hearing? And if the limit is extended, then is exceeded, perhaps a permission should be sought from the board. Yes, this is also our concern. It may not be appropriate to lay down a time limit in the law because that would affect procedural justice. Because for some cases, there may be reasons for them to be longer. However, when the TIA and disciplinary committee work out this working procedures, I think they will lay down guidelines on the appropriate length of time for, say, simple cases, moderately complicated cases, and complicated cases respectively. I think the TIA and disciplinary committee will keep in view the statistics in their regular meetings. When the statistics are available, they will be able to tell the average time required for an inquiry. You have added measures in the bill to expedite the handling of such cases. For instance, there can be a few inquiry committees running in parallel, and the size of the inquiry committee is smaller. We have expedited way of handling cases, and there is a mechanism for dealing with frivolous and trivial cases. And once the TIA is established, it will closely monitor the handling time, and I think the whole process will be more efficient, and for sure there will be improvement. Please bear with me if I am too long-winded. You may think that is the case, but in some cases it takes more than a few years. Of course, they will report to you, and you can scold them for being not efficient enough, and you can ask them to boost this manpower. Still, the process is far too slow. these licensees are businessmen, and if they have to attend your hearing a number of times, every time with their legal representative, then now if the scope of the complaint is beyond this bill, and if a fraud or criminal element is involved, the licensee might have already been taken to court. So I think you should set a time limit for the duration of an inquiry. There are time limits in your bill, for instance, 21 days for issue of notice, so on and so forth. And even the court has got statutory time limits. For instance, the time for lodging an appeal is within how many days. I'm not asking you to be too rigid, but can you say that, well, the case cannot be 120 days or 240 and, well, even 360 days. And once the time is exceeded, then the inquiry committee has to report to the board, giving reasons and seek permission for an extension. It was my suggestion. Dr. Zhang, whether we are talking about complaints and also disciplinary procedures, two parties are involved, and consumers currently have some criticism of the TIC procedure, saying that they take too long. No, I'm asking you to be rigid, but you should say that within 120 days an inquiry should be completed. No, I'm not asking for that. I'm saying that if an inquiry is not completed within the time frame set here, there should be a procedure for it to be reported to the board. Because the complainant, yes, I do understand. I think the Deputy Commissioner has already replied. There will be their standing orders. It will lay down a framework for everyone to follow. And if the procedures are exceeded, and the disciplinary procedure or inquiry committee will have to report to the TIA the number of cases and the reasons for the slow progress, so on and so forth. Yes, I think they will provide regular progress reports to the TIA. What progress reports? The number of cases that have exceeded the time, and to give reasons why some cases have been dealt with expeditiously and why some of the cases have taken so long, and suggestions for improving efficiency. I think that would be included in their procedures. So you are going to divide or classify cases into simple, moderately, complex? Yes. As regards how long it should be, we have to wait until TIA is established. The mechanism will run for a while, and then we will have an idea of the average time taken for a case and the reasons for the rather protracted time required for a case. Dr. Zhang, now if you are not happy now, I've given you 18 minutes. Perhaps the Deputy Commissioner can put down what he said in writing for our next meeting. And then you can decide how far you accept his proposals, and you can give counter suggestions. I know you are not happy with his reply, but you have to consider the consumer's perspective. So the Deputy Commissioner is saying that he is not sure how much time is required for a particular case, and for some few years may be needed. Is that what you mean? No, this is not what I meant. You now what is regarded as long? 50 days, 100 days? How many are there? And the classification of cases, we need to see what the situation is in the light of operational experience. And in the bill, we have added many measures to expedite the current process. So I think the future mechanism will be more efficient. To what extent, I think we can only tell in the light of operational experience. We will work with the TIA and see how they can closely monitor the situation. TIC has been operating for many years. It has dealt with many complaints. I'm sure it has got experience. Please tell us the classification of cases in the future, whether it's simple and moderately complicated and complicated cases, so that the public as well as the industry will know what is the progress, and when the time taken for inquiries is too long, then what procedures to follow. Because members of the public are worried as to when a hearing will end. Now you have added new measures, and you allow a few inquiry committees to operate simultaneously. Can you include all these measures in your paper for the next meeting? And please add the procedures, the standing orders for the TIA in the future. Clause 106, summons. The content of the summons and who is to sign, and this is to the arrangements for summons to be issued to assist the work of the inquiry committee. And then 107, prohibition on disclosure of inquiry matters. This is from Section 34(2)(b) of the Real Estate Agent Ordinance. This will prohibit or restrict the publication or disclosure by all or any of the persons present at the inquiry of any evidence given at the inquiry and any matter contained in any information or document provided or received in evidence at the inquiry. A person who fails to comply with such an order is liable to a maximum fine of $5,000.
Yes, Chairman. Yes, I have a question. Without this order, as you know, there are rumors always. Well, unless what is disclosed is in breach of law, the disclosure of information will not be in breach of this provision. And a consumer may be involved in the hearing, may be a party to the hearing. Now, he is not regulated by the TIA, but he feels unhappy about certain things. He feels aggrieved with regard to certain matters, and he gives his own view. That is unfair to the complainee. The complainant can disclose information. He is a consumer. Will he be bound by this provision? According to Clause 104, a complainant is also a party to the inquiry. If he participates in an inquiry, then the prohibition also applies to the complainant if the prohibition order is made by the inquiry committee. Before the order is made, then disclosure can be made. But after the order is made, then every party will have to comply. Yes, that's correct. Chairman, I want to seek clarification on one matter. Clause 105 does not spell out whether the hearing is open or behind closed doors. So I just want to know whether the authorities consider how the hearing is to be conducted. With regard to the hearing, which is being done by the registrar, the hearing involves certain business information and also comments by third parties on travel agents, even if if such comments are made lightly in an open manner, and such information may be uncorroborated or may be prejudiced or may be biased, then certain travel agent may suffer with regard to their business, and that will have an adverse impact on the operation of the travel agent's concern, and therefore the information should not be disclosed. And that's why we have this provision, so that the hearing can be conducted in a more objective manner. All right, no further questions. Let's move on. Clause 108, disciplinary orders. We also made reference to the Estate Agencies Ordinance. And you can see that upon conclusion of the hearing, disciplinary orders can be issued by the inquiry committee, from ordering a warning to revoking a license. You can see A to H, altogether 8 causes of action: warning, demerit points, fine, imposing licensing conditions, so on and so forth. As we said before, we make reference to the Estate Agency Ordinance. Subclauses 2 and 3 sets out the principles. The committee can take into account previous conviction records, previous orders issued by the TIA, to ensure that there is previous orders issued by the TIC. This is to ensure continuity. With regard to the imposition of a fine, the TIC at present have detailed rules for imposing a fine. That's in respect of with regard to not exceeding $300,000. If it is to be changed, the law will have to be changed. But for the rules for imposing fines, would that be in subsidiary legislation or guidelines? Now, as for the TIC, say for example, first conviction, second conviction, they are administrative arrangements. Such fine imposing arrangements, it will be up to the disciplinary committee. They can set out principles for dealing with various cases, and that can be dealt with by administrative rules. That will not be in subsidiary legislation. It is up to the TIA to decide on the details and standards of imposing fines. I believe it should be up to the disciplinary committee to set out the principles by administrative means, because severity of cases and also nature of cases, expectation of the trade and also the clients vary. It will be more appropriate and flexible to be done administratively. Now, it should not exceed $300,000. But the TIC did impose a fine more than $300,000. Will that situation occur? Our understanding is the maximum fine is $200,000. They did award $800,000 or $900,000, more than in one case. Per case, you mean per case? Yes, per case. As for imposing a fine of more than several $100,000, it may be because of repeated offenses by a travel agent. The TIC is based on the counts of offense. Previous offenses will affect the future fine. Will that be the same in the future? As I said, under 108, 2 and 3, subclauses 2 and 3, references can be made to the previous conviction records, including conviction records under the TIC. Say there are several offenses made by repeated offenses made by a travel agent. The TIC did impose heavier fines. This is allowed also in the future under the TIA. But the actual rules and principles will be set out by the disciplinary committee according to circumstances, including public expectation, the situation of a trade, and so on and so forth. A travel agent might have previous convictions, though not serious. It may suffer a fine more than $300,000, according to what you said. For a certain case, the fine should not be $300,000, but because of previous convictions, the fine may be heavier, more than $300,000. The travel agent who is fined may feel that this is in breach of the provision in this, because a cap is set at $300,000. It is $300,000 per case at most, just like the present situation, $200,000 per case at most under the TIC. If there are 3 cases, then the fine will be $600,000. It is per case. It is not because of a rollover basis that the fine for one case is more than $300,000. There is such a situation with the TIC. It is on a rolling forward basis. When the same offense occurs the third time, then the fine is much heavier. Yes, we know that is a rollover basis. This is up to the disciplinary committee to make a decision. If we find the arrangement effective, then the TIA can also make a similar arrangement so that repeated offenses of the same kind by the same travel agent may be handled more severely and a fine more than $300,000. Well, at the end of the day, if it is on a rollover basis, then the fine may exceed $300,000. Now you say $200,000 plus $200,000 plus $200,000, $600,000 for 3 repeated offenses. But my understanding is not like that. It's for one case that they impose $600,000. It's about the principle. So you have to clarify this. Now, after 108, we move on to 109. Offenses relating to inquiries. We've mentioned that before. Summonses issued under 106 by the, or rather 105, by the inquiry committee. If no reasonable excuse is given, one fails to comply with such summonses, the person has committed an offense. It is a criminal offense, and the fine and the penalty is similar to the estate agency's ordinance. Ms. Chen. Now, concerning a reasonable excuse, is there a definition for that? Or does it depend on whether on the judge who accepts the excuse or not? Thank you, Ms. Chen. It depends on the circumstances and information available as to whether there is a reasonable excuse. It is a criminal offense, therefore the onus is rather high. The TIA has to collect adequate information for the consideration of the DOJ before the DOJ can decide whether prosecution can be taken out according to this provision. Any further questions? If not, then let's move on. 110, Clause 110, notices relating to order about authorized representative. The inquiry committee may issue an order to a travel agent to cease to be travel agent's authorized representative. The procedure is similar to what is set out in Clause 28. That's about about requiring the travel agent to change its authorized representative. The wording is similar. The wording is similar, and you have seen them before. You have seen that before. Any further questions? Is basically similar to Clause 28, or rather to Cap 218. Okay, Clause 118. Application for approval of new authorized representative is about the proposed individual. You may refer to Clause 31, which we dealt with several meetings ago. The procedures are similar. The procedures are the same. There is an amendment to change, or there is a need to change an authorized representative. The provision seems to be long, but you have read them before, so I will not go into the details. As for the waiting time for the authorized representative, is there a time limit? Chairman, can you explain what about waiting time for authorized representative? Now, a new authorized representative will have to be made, but a new person cannot be found. Is there a time limit? Now, under 2A, if a notice is given to change the authorized representative, then within 14 days, the licensed travel agent will have to nominate another person. If the time is not adequate, then he can apply to the TIA to seek approval. Is there a cap? Say, when should he apply, or is it up to the TIA to decide? The principle is ASA to find a suitable person ASAP to be an authorized representative.
After all, authorized representative is an important role in the legal framework, and it's undesirable that the position is vacant. So we are asking for that to be done ASAP. We understand that in some cases flexibility is needed, and therefore upon application to the TIA, the period may be slightly lengthened, but the spirit is to appoint a new APAR as soon as possible. And during the period, can the company continue to operate? the company can continue to operate, generally speaking. Okay. No question? Then we have completed Division 3. We'll now go to Division 4, summary procedure of revocation or suspension of license. We said earlier that the chairperson may establish an inquiring committee to deal with procedures, but there may be circumstances that are more serious and immediate decision has to be made. Clause 112. Authority may revoke or suspend license in a summary way. The authority may revoke or suspend a licensee's license. That is following the arrangement in Cap 218. And there is Section 1992C. In case of serious breach of requirements, the committee can make a summary decision. Can you tell us if it is for a revocation or suspension of a license, what are the procedures? Who has the final say, or will it be done by a committee? If members may take a look at 1121. Under some circumstances, a summary way can be used to revoke or suspend a license. And there are ABCD4 scenarios. A, if the licensee fails to make an application or might have done so, but the application is refused. B, the authorized representative has either passed away or is incapacitated. C, the chairman receives a recommendation made by the chairperson under Section 1992C. And D, where Section 110 applies. That is, the licensee fails to make an application within the period specified, or he has done so but the application is refused. The TIA may revoke or suspend the license in a summary way. These are the 4 circumstances under which Clause 112 may be invoked. The summary procedures. Which body is responsible for exercising the power? When it comes to revocation or suspension of license, then under Clause 112, the authority is the party to take action. So we have 112 subsection 2 setting out the administrative procedures. A notice in writing will have to be given to the licensee, and then there will be a specified period for lodging an appeal. The authority can do so in a summary way. Will the procedure be made by the authority or in law? Because suspending the operation of a company is a big issue. So are there limits to the authority's power? Well, in Clause 112, subsection 1, we have outlined 4 scenarios, and they are very limited circumstances when the authority may invoke this clause. So if one of the 4 conditions here is satisfied, then subsections 2 and 3 can take place. So the authority can decide whether a license should be suspended or revoked in consideration of these 4 things. Well, if one of the 4 conditions here is satisfied, then the authority can invoke or suspend the license in a summary way. All right, 113. Authorities' additional power to revoke or suspend license in summary way. This is also made reference to the travel agent ordinance. And this is when the licensee fails to pay a registration fee, or the travel agents has ceased to carry on travel agent business. So this is clause 113. Please continue. Clause 114. Authority may shorten period of suspension or lift suspension. This is made reference to Section 27, 6 and 7 of the Real Estate Agent Ordinance. Now here, consumers are involved because during a period of suspension, some tour groups may have to depart, and tour fees have already been charged. All right, fees already charged, but no stamp duty. So, will you have any arrangements to tidy up the situation afterwards? Subclause 2. If the authority decides to shorten the period of the suspension of a licensee's license or lift the suspension, it must have good cause. So even though the license is suspended for a short period of time, that doesn't mean that the licensee cannot operate anymore. If for good cause the authority may shorten or lift the suspension, because once the license is suspended, then operation is also suspended. And what will happen to the clients? You should say something here about the transitional arrangements. Perhaps you can wait until Mr. Lee has come to clause 115. Even though a license is revoked or suspended, the liability or obligation under an agreement will not be jeopardized. Mr. Lau Kwok-Fan, Chairman, you've pointed out a very pertinent question. I'm concerned about how the obligation or liability can be honored when a license is revoked or suspended. There is bound to be a short period of time when there is no one to honor the obligation under an agreement. Although the travel agent is still required to honor its obligation after its license is suspended, but there are activities that only a licensee can carry out, and that can include affixing a stamp to the agreement. That is for the agreement to be stamped. The licensee may have the intention to do so, but he is not in a position to do so because the license is already suspended. Thank you. Said by Mr. Liu, Clause 11A is modeled after Section 31 of Travel Agent Ordinance. Although the license is suspended or revoked, that does not affect or operate to avoid any rights, obligation, or liability under any agreement. As regards the scenario described by Mr. Lau, We understand that the Travel Compensation Fund committee is dealing with that. Yes, the agreement is still valid, but he is not in a position to do it because the bank account may already be frozen. So how can that party honor its undertaking or obligation? Thank you. 115 has made reference to Cap 218 Travel Agents Ordinance. So, suspension of the license would not affect any right, obligation, or liability under any agreement. Liability would include, because the license is still there, it's just suspended. We want to stop the following. First, there must be a clear message to consumers that this travel agent is problematic. It cannot carry out new transactions to safeguard public interest and consumers' interest. If a travel agent has a disciplinary issue, if after the disciplinary procedure it is confirmed, then a fine may be imposed or his license may really be revoked. Here it says that suspension or revocation will not affect its right, obligation, or liability. For instance, it may have to have an agreement stamped. This is to set out the situation. If the travel agent, or before its license is revoked, has financial problems, for instance, insufficient balance in its bank accounts, well, this is not direct bearing on the suspension. If the travel agent is already insolvent, then it has to be dealt with in another way. So you will not include the collapse of a travel agency? We have to protect consumers, and the license has to be suspended because we don't want the problem to snowball. Meanwhile, we don't want previous transactions to be affected. This is not related to the. This may not be related to the financial situation of the travel agent. If there is a financial problem, then the loss of consumers will have to be claimed in another channel. Mr. Lau.
Now, according to the what is said by the Assistant Commissioner, that is exactly my concern, and that's about the compensation fund. I think the Assistant Commissioner and also representatives of the fund and also exchange views. I met with the chairman of the compensation fund. They had the first meeting, I know. They discussed some details, and they need further discussion on the details. And this section is related to this division is related to another division of the bill. I don't know whether they will clarify this. And I'm waiting for clause 139. And this part is also related, and therefore I raised the question. You do not provide clearly in the bill when is the time for imposing a stamp before the stamp is accepted by the compensation fund. Few people now go to travel agents to conduct a transaction. They may do it online, or most of them do it online. And there was they had a start in March. Now, say I put the money into the bank and then you send me the stamp. There is a time gap. It's different from what is said in the law. When you make a payment, then they will give you the stamp immediately. So the operation is different from what is provided for in the law. And the law does not spell out when does the stamp come into effect. There is an ambiguity here. Now, the travel agent in question is in the situation of having the license revoked, but this is still a process. In the future, there may be similar cases. It may not be a stamp. Now, they may have some loose ends to tie, but the license is revoked. And how should that be handled? I think the present provision is related to the compensation fund. I think there are two aspects. For one reason or another, the license is revoked. The travel agent still has to honor its commitment and promises to the clients. And in the other situation is that it has winded up. It has wound up, and therefore it cannot come. It has no resources, and it can do nothing. But if you just revoke the license, it has no license. It cannot continue to do business. But the contract signed in the past is still effective, and the accounts are still in operation, and they can still pay. Chairman, I agree with you. There are two aspects. First, clauses 114 and 115 concerning suspension or revocation of the license and the effects. They are different from handling the stamp. We explained that suspension or revocation will not have any bearing on the liability of the travel agent. As for the mechanism for handling the stamp, said by Mr. Lau, we'll discuss that under clause 139. I don't know whether we have time for that today. As for the handling of cases, it is another aspect, and that is the application of a provision to a specific case. It depends on the circumstances of the case, of course, and we have to trust the management committee of the compensation fund. Now, they are handling compensation under Cap 218. Now, they will call another meeting, and it is not appropriate for us to discuss how the compensation should be paid with regard to that specific case. I believe they will be reasonable and they will comply with the law in handling that specific case. It is not the appropriate juncture for us as third parties to discuss how that case is to be handled. Under 115, is it possible to add a provision that without prejudice to the interests of the consumers? Now, if you revoke the license, the interests of the consumer should not be prejudiced. Can you put that in? I think, though we do not mention the consumers here, the intention is to protect the consumers. We will talk to the law draftsman to see if we can clarify this aspect. The purpose of the TIA is to protect the consumers at the same time to enable reasonable operation of the business. Any further questions? Let us move on to privileges and immunities. Clause 116. Whether it is the inquiry committee or those who appear before the inquiry committee, the privileges and immunities are the same as if the inquiry were a proceeding in a court. We have seen similar provisions before. Here we just spelled it out more clearly under clause 116. As for 115, apart from the consumers, I think the parties to contracts or agreements should also be included. Otherwise, it will give the travel agents an excuse that the account is frozen, therefore it will not pay. We are now on clause 117. So far, before 117, do members have any queries? If not, then we move on. We still have 6 minutes left. Do we have enough time to deal with Division 1? With your permission, we try the best, Mr. Chairman. Clause 118 provides that the Secretary will appoint an appeal panel to deal with appeals. In Part 8, the appeal panel should at least be appointed by 18, shall at least be made up of 18 individuals, and the term will not be more than 2 years. All the public officers, members of the authority or disciplinary committee, members of committees or working groups under the authority will not be members of the panel. In other words, they are not related to the TIA. This is to ensure that the appeal board or the appeal panel will fairly deal with the appeals. Now, is there any cap on the appeal board? Well, under 122, there will be composition of the appeal board, and we'll discuss the details. 119 is about the appeal, or is about the resignation of members. Members are allowed to resign, and the Secretary can also dismiss the member. This is similar to the arrangement with regard to the powers of the TIA. Is it similar to the arrangement of the TIC now? Now, this is an arrangement according to the law, whereas the arrangement of the TIC is according to its memorandum and article of association. 121 rather, appeals against decision. There are 9 matters, A to I. Decision by the TIA, a decision by the committee of the committees of the TIA. They are all subject to. They are all matters that can be appealed under Section 121. If one is aggrieved by the decision, then within 28 days an appeal can be made to the Secretary. And the basis is Clause 121. Mr. Lau, for those who lodge an appeal, or rather for the matters under appeal, they are matters related to licensing. And there are fines imposed by the TIA. If one feels the fine unreasonable or certain things are ambiguous, then can that be subject to appeal under 121? Mr. Lee, if you refer to 121AH, an order made under sections 1992B, 1081, or 5, they are exactly on the judgment or the fines imposed by the chairman of the disciplinary committee or the inquiry committee. That's about license fines in relation to licensing, about revocation, and things like that. Mr. Lau, do you have anything to ask? No more. Thank you. I think we are about time to call it a day. The date of next meeting is the 16th of May, 8:45 a.m. Thank you. The meeting is now adjourned.